Hey, y'all. Happy Friday. Boy, do we have a lot to talk about tonight. There have been a number of interesting filings filed in the Vallow Daybell case, and just yesterday and today. Um, leave it to lawyers to file things on Friday at 4 o'clock or Friday at 5 o'clock. So we have a bunch to talk about. All of these new filings, I know everyone is anxious to hear about um, the motion to dismiss on speedy trial, and I am going to cover that extensively, and we're going to talk about it. Excuse me, and I'm even going to read the motion. But I want to give everybody a chance to catch up. So we're going to talk about some of the earlier motions that have been filed. And one thing that showed up in the court record, which is kind of interesting, is a couple of subpoenas for on Lori's behalf, and those subpoenas are a subpoena for all of Lori's church records and a subpoena for all of JJ's Gilbert school records, which is kind of interesting. I don't know what to make of that. I don't know why her attorneys want that information, but I suppose we'll find out at trial, provided there is a trial. We have heard rumors that there are plea negotiations going on, but we're seeing motions as if everybody's steaming full speed ahead. So now understand that pleas can, that settlement can come right up until really trial or even during trial. Plea bargains can happen even after the jury is seated. So it won't be incredibly shocking if a plea comes along, but I think the closer we get to trial and the less likely it gets, the more work that the attorneys are doing to get ready for trial. So the judge did a couple things that are kind of clean up from from the last hearing that was on the 19th. He entered a couple of orders. One was denying the motion to sequester the jury, and the other was denying the motion to allow Chad and Lori to meet in person. We knew that those were coming, but the judge did enter orders to those effect. Now he is still not produced decisions on some of the death penalty motions that were filed, motions to find the death penalty unconstitutional, and all of those motions. We haven't seen any written opinions on those yet. So, but there were a couple of interesting, other interesting things in the court file. One is that there was a discovery request for any additional ring camera footage if it exists. Now we know that that JJ was caught playing with the neighborhood kid. It was caught on the, not caught. JJ was playing with the neighbor child, and it was caught on a Ring doorbell. That's a better way to say it. And that was released in the Arizona data dump. But they're asking for any other doorbell camera data that might be available from September through October. So it sounds to me that like they are looking for Ring doorbells that might show movement among the apartment complex, perhaps movement between Alex and Lori's apartments, movements, because the alibi document, which there's also some information about that in here, in these recent filings, the alibi alleges that the children were killed in Alex's apartment and that Lori was in her apartment when it happened. But the prosecution has demanded that they make more certain exactly when that alibi happened, because it's kind of vague about where and when, where Lori was when, so that she couldn't have been there during the time the children were murdered. So they are waiting. They want a response to that. They're asking. There were two things they were asking for that they've asked the court for an order to compel them to produce. One is the timing of the alibi, and the other is any experts or evidence that they intend to put on during the penalty phase. So you might recall things change during the penalty phase. So some things are more lenient, but some are less. So, for example, they do not have to provide a complete list. They do not have to give notice. Let's put it that way. They do have to give a list of witnesses, particularly expert witnesses, but they don't have to notify the prosecution if they intend to present mental health or mental disease or defect evidence during the penalty phase, during the decision whether or not the death penalty will be imposed. Also, during that period, the jury has to be sequestered. So, one of the really interesting pieces of evidence that came out today is that the defense or the prosecution filed a record with the court saying that they had produced the DNA evidence that everyone was concerned about. If you recall, there were two problems with DNA. The first was that there was DNA that back in August, they agreed to a procedure for how it was going to be tested because it was likely that that DNA was going to be consumed in the test and there wouldn't be any left over to do additional testing on, or for the defense to have their own scientists confirm the test. So they came up with a process for how they were going to handle that DNA back in August. And so far, when we were at the hearing on the 19th, the defense had still not received any of those reports. In addition, there was additional DNA discovered, likely in the like the tape, the duct tape. Sorry, took me a minute there. That the JJ's body was wrapped in. And so what was discovered apparently were a couple of hairs. It was unclear whether the lab was going to be able to lift any DNA out of that, from that hair. But John Pryor argued, and rightfully so, that he was entitled to have all of that discovery, because if there's any chance that that discovery material is going to be exculpatory, he has an absolute right to get it ahead of trial. So what's interesting is, after hearing all the argument, Judge Boyce said, I am not going to continue the trial, because John Pryor's argument was that he wanted a continuance. He wanted the trial postponed again because of the lack of this evidence. And the judge said, I'm not going to postpone the trial. The trial is going to go forward on April 3rd because Lori has not waived her speedy trial rights. And that juicy thing is coming up next. So Lori has not waived her speedy trial, which means that I need to move this case along. However, if Mr. Pryor has not received the DNA evidence that is potentially exculpatory, then I have no choice but to sever the trials. And so the judge made clear that if that DNA evidence didn't come in time for, in a reasonable amount of time, he would consider severing the trials and continuing Chad's case to allow his experts to review the DNA. And lo and behold, that hearing was on the 19th. And on the 25th, with an intervening weekend, the state filed a notice with the court that they had provided that DNA, both of those DNA results, the reports. So it amounts to about 3 working days. And they ended up being able to light a fire under the crime lab and get that stuff moving. We knew that was possible, if for no other reason than we knew it because the DNA that they used to identify Brian Kohberger in the University of Idaho case got turned around in maybe as short as 24 hours. We know that because we know from the probable cause affidavits and the search warrant affidavits that they, the officials back in Pennsylvania, secured that material, and it was transported, probably hand carried, to Idaho, and it was the Idaho Crime Lab who processed those samples. So we know it can be done if a little bit of encouragement comes in from the prosecutor. So I thought that was interesting. As you all know, I always want to sort of jump right into all of the new information to give you what we know. And then at about the half-hour mark, we'll ask for questions. So please hold your questions until we have the opportunity to do that. It's much easier for our moderators to spot questions if they're not looking for them all the way through the whole chat stream. Also, if you would, in your chat, write the word question to start your question. That really helps them be able to identify and find those questions quickly. So I do have a couple of questions about Alec Murdaugh and that trial, as well as a couple of questions about Brian Kohberger and the University of Idaho. I am going to answer those later on this afternoon or this evening, sorry. But I'll answer those 2 short questions, and then we'll hold the rest of them for True Crime Wednesday, next Wednesday, when we talk about other cases, because there's so much to talk about in the Vallow case. Now, the biggie, the one everybody is concerned about, is the motion to dismiss for speedy trial. Now, I have a new newsletter coming out. It'll come out tomorrow morning. And in that, I go through the entire analysis. Y'all know me, and y'all know that when I express an opinion, it's because I've done the research, and I want you all to be able to assess my assessment of it, because reasonable minds can differ, and we're going to see that when we talk later about the Kohberger case. Reasonable minds can differ about the interpretation of the law. That's why we have judges and Supreme Courts and people to interpret. But I do outline my thought process and the law in my tomorrow's newsletter. So look for that if you want to really take a deep dive into this speedy trial issue. Now, I don't usually read motions because I feel like I don't want to waste the time that we have together doing it. But I do think this one is worth reading to make sure that everybody understands what they're asking for. So this motion was filed by Jim Archibald and John Thomas, who are Lori Vallow Daybell's attorneys. And it is titled Motion to Dismiss for Lack of Speedy Trial. Now, if you recall, back when we were in court, when the trial date was set, so that would have been November 8th, I think. I can't keep all these dates in my head, but I think that's right. When the new trial date was set, the judge continued or vacated the January date because Lori was in the middle of being assessed for competency again. And when the trial was reset, Jim Archibald stood up and said, "We believe, based on how we've calculated all the periods that she was incompetent, we believe that this trial needs to be set no later than, it has to start no later than February 21st. So the judge then went back to Ada County and came back and said, April 3rd is the date. Now understand that Judge Boyce has absolutely no control over Ada County Court. And the Ada County Court is going to set that court date based on their docket, based on whatever else is going on in their court. And so, and remember, this is going to be huge, going to be a huge trial. There's going to be way too many people there. It's going to be overwhelming for Ada County, and they know it. And so they're doing their best to accommodate this monster trial from out of town. So the judge set the date for April 3rd, even though Jim Archibald said it has to be by the 21st, or we're going to file a motion to dismiss on speedy trial grounds. So this shouldn't be a surprise. Archibald said he was going to file this. So let me just do a quick read through here. Comes now the defendant through her attorneys and pursuant to the Constitution of the United States, Amendment 6 and the Constitution of the State of Idaho, Article 1, Section 13, and Idaho Code 19-3501. Moves the court to dismiss this case as the government has violated her right to a speedy trial as follows. Whoops, I got my pages out of order here, so bear with me. In fact, it looks like, oh, here it is. It was all marked up. The accused shall enjoy the right to a speedy trial according to the Constitution of the United States, Amendment 6. The accused shall have a right to a speedy trial according to the Constitution of the State of Idaho, Article 1, Section 13. Since the term speedy trial does not specify the length of time required to bring an accused to trial, federal law enacted a timeline for someone charged with a federal crime, and each state in the union enacted laws to define what it means in their respective state. The Idaho legislature defined speedy trial in Idaho Code 19-3501 as follows. The court, unless good cause to the contrary is shown, must order the prosecution or indictment to be dismissed in the following cases. And then he jumps down to the applicable paragraph. If a defendant whose trial has not been postponed upon his or her application is not brought to trial within 6 months from the date that the defendant was arraigned before the court in which the indictment was found. Then he goes on to talk about a case called State v. Clark. Now, what my research shows is that up until State v. Clark was decided in 2000, which is pretty recent, the state of Idaho was using a U.S. Supreme Court case called Barker versus Wingo. And Barker versus Wingo actually enumerated 4 facts that the court had to look at in determining whether or not speedy trial had been violated. So Clark changed that a little bit, and so Clark is actually the law in Idaho. So let me read their excerpt here. In that case, the determination of good cause, here's the quote, upon careful consideration of the relevant authorities, we believe that a thorough analysis of the reasons for the delay represent the soundest method for determining what constitutes good cause. We therefore conclude that good cause means that there is a substantial reason that rises to the level of a legal excuse for the delay. Because there is not a fixed rule for determining good cause for the delay of a trial, the matter is initially left to the discretion of the trial court. The good cause determination may take into account the factors listed in Barker versus Wingo. That's the U.S. Supreme Court case. The Barker factors, however, are considered only as surrounding circumstances are important, if at all, only insofar as they bear on the sufficiency of the reason itself. The shortness of the period, the failure of the defendant to demand a speedy trial, and the absence of prejudice are legitimate considerations only insofar as they affect the strength of the reason for delay. So here's the important sort of telegraphing the rule. This means that to whatever extent the delay has been a short one, or the defendant has not demanded a speedy trial, or is not prejudiced, a weaker reason will constitute good cause. On the other hand, if the delay has been a long one, or if the defendant has demanded a speedy trial or is prejudiced, a stronger reason is necessary to constitute good cause. Thus, the ultimate question of whether legal excuse has been shown is a matter for judicial determination upon the facts and circumstances of each case. A trial judge does not have unbridled discretion to find good cause, however, and on appeal, we will independently review the lower court's decision. So now they go into the timeline and they list out each period of time, and they say 1,169 days in jail without a trial on any of the 3 cases. Now remember, there was an original case, a misdemeanor case, well, there was 1 felony, a low-level felony, and several misdemeanors in Madison County. That was the very first charges, failing to protect the children, abandonment, those kind of things. Then there were charges that were filed right after the children's bodies were found, and those charges were more serious, but still not murder. They were destroying evidence and those sorts of things. The first trial setting in this case, in the murder case, was for October 11th of 2022. Since that was within 6 months of April 19th, 2022. The government then asked for more time, and the court granted the request and set a trial for January 2023. This violated her right to a speedy trial. Lori Vallow Daybell's defense team questioned her competence to stand trial, and the court told the case means that time didn't count against speedy trial. From October 6, 2022 until November 15th of 2022, a 40-day delay caused by the competency review doesn't justify a trial setting 3 years after her arrest and almost 1 year after her arraignment. Now, there's a little bit of a complication there because she was found incompetent to stand trial in October of 2022. She actually was found to be incompetent and spent about 10 months in treatment, was found to be competent in April of 2022. Then in November of 2020 or October of 2022, her attorneys once again raised the question. And the judge, during that period where the judge had stayed her case again, vacated the January hearing. So it says the government still has an obligation to bring her to a speedy trial, which complies with the Constitution and Idaho Code. From her arrest on February 20 of 2022 until the current trial setting on April 3rd is 1,169 days without a trial in any of the 3 cases. From her arraignment on this case in April of 2022 until the current trial setting on April 3rd of 2023 is 349 days. Obviously more than the statutory 6-month time limit. Her constitutional rights, including her right to be presumed innocent and her right to a speedy trial, have been ignored by the government. It is undisputed that Lori Vallow has demanded her speedy trial and has never waived her constitutional rights. She is prejudiced every day since she is in jail and unable to post bond. The court has repeatedly reminded the government that it will respect her constitutional right to speedy trial. The government cannot show good cause to bring Lori Vallow's Daybell to trial over 3 years from her arrest and almost 1 year from her arraignment. This court should find that the government has not met its burden to uphold her constitutional rights, and the case should be dismissed. Now, we've had this conversation just as a reminder. If this judge were to decide that her constitutional rights had been violated, he could order that the case be dismissed. He could also determine whether or not that dismissal was without prejudice, meaning it could be filed again, or with prejudice, meaning it could not be filed again. The more likely outcome is that the judge is going to let the trial go forward as scheduled and let the appellate court deal with it. What this motion does, though, for Judge Boyce, which is probably a boon for him, is it allows him to sit down and write a written opinion in which he outlines his reasoning in determining that her speedy trial, that there was good cause to violate her speedy trial by 40 days, which is essentially what the argument is. Does 40 days beyond what her attorneys say is the deadline violate her speedy trial rights? And as the case in Cook said, it's not a slam dunk, and it runs absolutely on the facts of each individual case, and it runs at the discretion of the judge. So although the appellate court can review whether or not her speedy trial rights were violated, what they're really going to be reviewing is whether or not Judge Boyce abused his discretion. So the better Judge Boyce can document his decision for continuing the case to April, the less likely it is that there's going to be a challenge, the less likely there is that the appellate court is going to dismiss the case. Now, if the judge had granted the continuance that Chad Daybell wanted and moved this case out until October of this year or even April of next year, that would have been a clear violation of her speedy trial rights. And it would have been so egregious that it would be likely that the court would say with prejudice, and would dismiss the case. I think it's unlikely that the court is going to order dismissal with prejudice for a 40-day delay. And particularly where these factors are factoring in the fact that what caused the delay from January was her competence. Now, in general, being incompetent doesn't count against the defendant. So, for example, if you are a defendant and you ask for a continuance of your trial, even if it's still within the 6-month window, even if the rescheduled trial is still within the 6-month window, in Idaho, they consider that you have waived your speedy trial right. Now, Lori has never done that. She's never asked for a continuance. She's always exerted her right to speedy trial. And the only delays that can be attributed to Lori have to be attributed to the questions about her competence. That doesn't, in the mind of the appeals court, count against Lori. But you can't help, but the appeals court will not be able to help but take notice of the fact that it was her competence, questions about her continued competence, that meant that the January trial had to be once again postponed. So when you couple that with the fact that they're in Ada County, in a county where they don't have any control over the court docket and when things get scheduled, I think that the Supreme Court would likely find that there was good cause for the delay. Primarily, the good cause was that they did not believe that Lori would be able to go to trial in January because of the questions about her competency. As it turned out, the experts said she was competent, and they actually could have had that trial in January. Although, if I were her lawyer, I would be arguing during that time, we were concerned that she couldn't participate in any of our trial preparation. And so essentially, we lost that time because she was absent and not able to help us. So it's an interesting question. I don't think anyone should panic. I don't believe Judge Boyce is going to dismiss this case on the basis of speedy trial violation. I don't believe that because he's the one who set this date in April. If he had been the least bit concerned about not violate or not getting the case dismissed because of speedy trial, he would have moved heaven and earth again to try and set it on February 21st. Even if it meant starting the trial on February 21st and then continuing the trial on April 3rd. And I've seen that happen before too. And it's legal. What the rule says is that the trial has to start before the end of the speedy trial process runs. So I don't think that there's any chance that Lori is going to walk on these charges. I think the Supreme Court is going to support Judge Boyce and say, yes, we believe that that there was good cause for those 40 days that they are past the end of the speedy trial period. And I don't believe that the appellate court will overturn it. But anytime you're dealing with speedy trial issues, it's dangerous because unlike a lot of other remedies in constitutional cases, in other remedies, you get a new trial. When it comes to speedy trial, if the court finds that it is violated and it is serious enough, your case gets dismissed and it's as if you were found not guilty. So we don't want to see that happen. I don't believe Judge Boyce wants to see that happen. And so I do believe we're going to see this case go forward, and she is not going to walk. Now, some really interesting things happened this afternoon at like 3 or 4 o'clock when these documents dropped. And I know I want to get to questions, but I want to quickly just talk a little bit about those. There were a whole series of orders asking to seal hearings and seal proceedings. And there was what amounted to an emergency hearing today on ex parte motions. So everybody jumped to the conclusion, because the only other ex parte motions we've seen have been those having to do with Lori's competency. If you recall, the only other time that we've seen ex parte means only one side is having contact with the judge. And in general, that is not allowed. And there are some limited kinds of circumstances where one side can contact the judge without having the other side present. So we all, because that's the only thing we've seen in this case, want to jump to the conclusion that this is a mental health issue. It is not. If you look at the motions to seal the proceedings, it is that there are things that they have asked the judge to review in chambers and to make determinations about. And part of that has to do with the jury questionnaire and the jury questions. So we don't know for sure what all of this, what the judge is reviewing, although we do know in one case that the motion specifically talks about jury instructions. We don't know what material it is that the judge is being asked to review. Often the judge is asked to review things like mental health records or medical records, and to determine what's going to be admissible and what's not, what's protected under the law so that it's not released to in public. So, and right along with that is a motion in limine. And motions in limine are really interesting things too. We talked about motions in limine on Wednesday when we were talking about the Alec Murdaugh case down in South Carolina. And what a motion in limine is limits. It is a motion asking the judge to make an evidentiary ruling on a piece of evidence prior to the trial. And a ruling that says, Judge, I don't want to argue about this in front of the jury because I'm afraid to ring that bell. I don't want the jury to hear anything about this information until the court has ruled whether or not it's admissible. And so the lawyers will file a motion in limine and they go before the judge, usually in a sealed hearing, because they still don't want any this information made public until the judge makes a ruling. And so what they do is they present all the evidence to the judge, and the judge makes an evidentiary ruling on whether or not that information can come in. And then if the judge says, yes, I think it comes in, then it can be presented. If, on the other hand, the judge says, no, you're right, this is information that should be limited and shouldn't be presented to the jury, then the judge issues an order that says, this is a limiting order. It specifically says that you cannot, in trial, bring up this XYZ information. So the motion in limine had to do with Chad Daybell's mental health. This was the other reason why everybody panicked when they saw those ex parte motions, because it's like, oh, it's all about mental health, and now we're talking about Chad's mental health, and it all just kind of gets wrapped up. So let's sort it out a little bit. If you recall, not very long ago, Lori's attorneys filed a notice saying that they did not intend to raise the issue of mental health at trial. And they were doing that because it was a requirement in the law that they had to make that determination 90 days before trial. Now, Chad's attorneys never filed that kind of a motion. And so now the state is saying, you didn't file your notice saying that you did or didn't intend to raise mental health. And now we want the judge to say you can't bring it in because you've waived the right to do that because you didn't give us notice 90 days before trial. That's all this is about. There's never been any indication that they were going to raise a mental health defense for Chad. So it's kind of a red herring. The prosecution is trying to protect themselves by saying, we want a ruling from the judge that says you waived it, you can't bring it, because I don't even want the hint of a mental health issue coming up in front of the jury. Makes perfect sense from the prosecution's end of things. So I wouldn't panic about either one of those. The ex parte motions, I think, have to do with the judge reviewing records in chambers and making evidentiary determinations. Likewise, the motion in limine has to do with making an evidentiary finding. And it has nothing to do with them raising an 11th hour mental health defense for Chad. So, the other thing is in those ex parte motions, one of those included a declaration from someone called Greg Hampikian. He is a biologist. He's from Boise, but he's the founder of the Innocence Project and an expert on DNA, and was very involved in the Amanda Knox case. So that tells you what kind of information they're asking the judge to review in chambers. It has to do with DNA and who's going to be an expert. So that was the reason why they had this, what seems like an exigent or an emergency hearing today. And that was to present this stuff to the judge and ask the judge to make an in camera, which is the Latin for in chambers, ruling on that evidence. These are all very typical things that are going to happen in advance of a very complex criminal trial. So none of this is really surprising. If anything, it's a little surprising that we're seeing it now. We didn't see it 6 months ago or 3 months ago. But I don't think anybody should panic. Lori is not walking away from this trial. Chad is not going to be declared insane. He's not raising mental health issues. And I sincerely believe this trial is going to go forward in April. And I have said all along that I believe that there are going to be a number of appellate issues that come up. And we'll just have to wait and see what the appeals court does with those. But I don't believe Judge Boyce is going to do anything except kick the can down the road to the appellate level once this trial is done. So I think we're going to see a trial. I know we're going to see the guilt or innocence phase. If they're convicted, we're going to see a penalty phase where they discuss whether or not there's mitigation that would keep them from imposing the death penalty. So those are all interesting things to watch for. The other thing that I wanted to say, a couple of things about a couple of other cases. One, if you have not had an opportunity to watch Law and Crime's coverage of the Murdaugh case, and specifically Gigi, our friend Gigi from Pretty Lies and Alibis, her coverage, she's doing a bang up job, and I encourage you to tune in to Gigi and to tune into Law and Crime. There have been several questions about the Kohberger case and the potential conflict of interest with his attorney. And Ashley Banfield from News Nation, I think it is, has drawn a lot of criticism, I will put it that way, for her interview with Xana Kernodle's mother. So quick thumbnail, because I don't want to run out of time for questions. Although we might go a little over tonight because we've got a lot to talk about. Everybody knows University of Idaho murders. 4 students were murdered. Brian Kohberger was taken into custody and is accused of the crimes. Moscow and the surrounding area, that whole part of Idaho, very small, very rural. We're talking about small jurisdictions, much like Fremont County and Madison County, much like those jurisdictions. And so small jurisdictions where you've got a handful of lawyers who are public defenders and who are doing all of that incredibly righteous work. I'm going to tell you, I did public defense work. I know how it works. I know what happens. The state comes in and says, you are our person we want to appoint to this case. In this case, Ann Taylor was appointed to represent Brian Kohberger. She is the only death penalty qualified or capital qualified, lead counsel qualified attorney in her judicial district. Most judicial districts in Idaho are made up of several counties. So the state very promptly and logically said, we're going to take the only qualified capital attorney and appoint her to represent Brian Kohberger. Now, what that means is that she needs to clear the decks on a lot of other cases, because this is the first murder they've had in the area in like 7 years. So it's not like she's been sitting around waiting for the next murder case to come up. So she's got a full caseload of other clients. And the state comes in and says, we're appointing you. You need to transfer out all your cases. And the state is very, they call the shots. They are the administrator of the public defense funds. And so they tell her, you need to get rid of all your cases. In the process of doing that, she also recognizes that she has in the past represented the mother of one of the victims. And she files a motion to withdraw, substitutes in another very competent attorney to handle this woman's possession charges. She is a person who has had lifelong drug and alcohol issues. She lost custody of her children. She's a desperate addict. And unfortunately, the folks at News Nation got her to come on Ashley Banfield's program and talk about her feelings and her disappointment at not having the same lawyer. Now, I can tell you that public defenders, clients move back and forth between public defenders all the time. Sometimes it's a conflict. Sometimes it's as simple as this, I've represented this client before, or Yeah, I mean, I've had cases many times where I've said to the state administrator, "Hey, I know this client." And, sometimes when you know your lawyer or you've had experience, things go easier. So if you want to assign that client to me, I'll swap one of my current cases to the attorney who's assigned to it. And so cases move back and forth pretty frequently among public defenders anyway, even when there isn't a conflict. So I put out a newsletter in which I outlined the rules of professional responsibility that control Idaho lawyers and the reasons why I believe it is not a conflict. I still believe it is not a conflict. Reasonable minds can differ. But the lawyers out there in LawTube who I also value their opinions and believe that they are um, giving out good information have confirmed that they believe that's the case. Now, there have been lawyers on News Nation, talking heads, who have disagreed and said this is a clear case of conflict. It's not. It's not a conflict. There's a bunch of people out there who have said, well, they've got this big conspiracy theory that somehow Xana and her mother were involved in drugs, and because Brian Koberger used to be addicted to heroin, it could be this big drug conspiracy. And if it is, then Ann Taylor would have a conflict because she previously represented. I mean, it is absolutely convoluted reasoning. It is absolute speculation. And nobody bases a conflict on speculation. Everyone bases a conflict on what is happening. Now, can a conflict arise down the road? Absolutely. If information comes to light that shows that this attorney now has a conflict that they didn't know about before because new information comes forward, then that attorney would be required to conflict off the case. But that is not the case right now. So Ann Taylor is a very accomplished criminal attorney. She's been doing this a long time. I'm certain that she was confident at the time that she transferred Kara Kernodle's case to the other attorney that it was absolutely not a conflict. So before we jump into questions, and I will go a little long tonight because I've gone a little long and cut into your question time. So before we do that, I just want to remind everybody, if you have not subscribed to the channel, please pop out and do that. Please hit the like button. There are 391 people watching right now. I hope we're going to get 391 thumbs up. Please hit the like button because it does make a difference with the YouTube algorithm. The problem that many true crime kinds of channels have is that we already have a little bit of a strike against us because we're talking about material that can kind of ride the fence line when it comes to YouTube standards. So we try and be careful, but it's super important that you all hit the like button and let YouTube know that this content is important to you, because that makes a difference in how they view our programming. So please do. The other thing is subscribing and hitting that notification button is going to mean that when we go live during the trial, you're going to get notified. Right now, we're doing Wednesday, Friday, very consistent shows. But once the trial starts, I'm going to be in that courtroom and I am going to be posting short videos as often as I possibly can to let you know what's going on. Because at this point, we don't know whether or not the judge is going to change his mind about the camera ban. Larry and Kay Woodcock have asked the public to contact Judge Boyce. I've been hesitant to ask y'all to do this, but Larry and Kay have asked the public to contact Judge Boyce and let him know that you want the trial televised and live streamed. They believe it's important for the family. I agree with them. I believe that it's going to be a terrible hardship on many of the family members of the victims, of the defendants, because the trial's in Boise and they're across the state. So I also believe it's going to be a very large hardship on the Ada County Courthouse, because they're going to have enough trouble just handling the media, let alone members of the public that want to come and watch. Members of the public that want to come and watch are going to be much more likely to watch the live stream. So I will put in the show notes to this show the address that you can send those letters to Judge Boyce. I'm only doing this because Larry and Kay asked for it, and they have been very public about asking the public to contact Judge Boyce. So we'll put that information in the show notes. With that, let's take some questions. I'm going to grab a sip of wine. Thank you, Lori girl, for your donation. One more thing I want to mention is that all of the super chats and PayPal donations that come in during a live stream go directly to our mods. And thanks to you, I've been able for the last 2 months to send each one of them a nice little check. And I know that for at least one of our moderators, it is making a huge difference for her. So those of you who can afford to be generous, please donate. I wouldn't ask you to do that if it were coming to me, but it's going to our moderators. So the only revenue that I'm seeing off of YouTube is the revenue that is generated by the ads that play when on the replays. It's not a lot, but a little bit goes toward the channel, and it sort of helps defray the cost of our internet and, a couple of online subscriptions that we need to have in order to make the channel happen. But everything that comes in from you goes directly to our moderators, and they really appreciate it, and it is making a difference for them. So Lori Girl's question is, didn't Lori's attorneys have to file to preserve the record for appeal? Absolutely. You cannot appeal something that you didn't raise at the trial court level. That's a good point. And I probably glossed over that because it's something that most lawyers are like, yeah, well, everybody knows that. So thanks for bringing that up. If you don't raise an issue at trial, you can't bring it up later the one caveat to that is ineffective assistance of counsel. They will let you bring that up because not everybody will stand up in their trial and say, my lawyer's a bozo and doesn't know his butt from a, never mind. Anyway, so ineffective assistance of counsel is generally, they can raise that after the fact, but everything else has to be raised at trial before it can be appealed. So absolutely, in order to have the appellate court consider the speedy trial issue, it had to be brought up at the trial level. Oh, good question. Bo Pete. Can Lori still testify against Chad if her case should be dismissed? What would happen as far as her case in Arizona? Both good questions. The question about whether or not she could testify is a little bit tricky, because the question would be, if her case got dismissed, was it with or without prejudice? If it was with prejudice, so that the charges could never be brought again, she could be required to testify because she would not have the Fifth Amendment right to protect herself against self-incrimination. If, on the other hand, the case was dismissed and the state could refile it, They could not force her to testify because she has an absolute right to remain silent in a case where she could incriminate herself. So a lot would depend on how the dismissal came down. And what would happen as far as her Arizona case would go? Arizona would go forward with their charges. I think, remember, she has never been arraigned on those charges. Her arraignment has been held for just this reason, because they don't want any speedy trial issues. So she's never been arraigned on the Arizona charges. And so they wouldn't later say that they violated her speedy trial. So that case could go forward. She is charged with conspiracy to commit murder down there. And from the things that we have seen have been dropped from the Arizona data dump, which we know is not everything, it looks like they've got a decent case. So why would Chad's, hello, Missy Bancroft. Why would Chad's alibi need to be sealed? Is it to keep Lori from seeing it and learning he's going against her? Okay. Chad has not filed an alibi. Only Lori has filed a notice of intent to use an alibi defense. Chad has not filed anything that he's going to raise an alibi defense. So the alibi, there was no request to seal an alibi defense. The documents that they were asking to seal had to do with the jury questionnaire and with potential mental health records, but I think they're probably Lori's mental health records, because there's no inkling that Chad was ever going to raise mental health. So Chad never filed a notice of alibi, so there was no request to seal it, but there was a request to seal several proceedings, including one having to do with mental health, as far as I can tell. So you have to kind of read the tea leaves with those, because you can't see what's actually been sealed. Beth Riggenbeck. At one level, it feels like Lori and Chad's lawyers are colluding to create the speedy trial versus continuance confusion. Can the lawyers be sanctioned for that? They could be, if that's what was going on. And I can see how, to the public, that might appear that way. And I don't want to defend either one of these lawyers, but I can tell you what my experience has been. And I don't think there's any confusion between a speedy trial and the continuance. Co-defendants' needs and their rights never line up perfectly. And so you're never going to get two co-defendants who are absolutely going to be on the same page in everything. So in this case, we have Lori, who has said, I want a speedy trial, I don't want to waive. We have Chad, who decided to waive with the advice of his lawyer. And so he doesn't have that same prohibition. He doesn't have that same bump in the road, if you will, as Lori does. So they've created competing interests for their clients. I don't think that's collusion. I don't think they're colluding to try and create a smokescreen. I think they genuinely have created a situation where their clients are at odds. Chad wants more time. Time works on the side of the defense. Lori wants a speedy trial now, for reasons no one's really sure of. But she has an absolute right to demand a speedy trial. So right now we have two lawyers who have perhaps created a situation where their clients are opposed to one another. But I don't think it's collusion in that kind of we're putting up a smokescreen kind of a way. Carrie wants to know, do I think that Arizona will bring more charges against others later? If you're talking about the rest of the inner circle, the Melanies uh, and Zulema, I doubt it. The reason I doubt it is because any charges that would have been brought against them would have been brought in Arizona because the crimes occurred in Arizona. And Arizona participated along with Idaho in coming up with what we believe are immunity deals for those three. If they fulfill their obligation in the immunity deals and go and appear and testify truthfully, then I don't think that we're going to see charges against them in Arizona. I know that disappoints a lot of people because I know that there are a lot of people who feel that the two Melanies and Zulema should have more accountability. And I don't necessarily disagree, but remember, the state's making a deal with the devil. You know, they're making a deal because they are more concerned with making sure that Lori and Chad don't get away with murder. And so they're willing to deal away what could have been other prosecutions to make sure that these people who have material evidence against the murderers come to court and testify honestly. So I don't think we're going to see a lot of more prosecution of them. Now, that doesn't mean they can't be prosecuted for crimes that happen separate from the crimes having to do with Lori and Chad. I mean, if they go out and rob a bank tomorrow, all deals off. They don't get immunity from that. They get immunity. Their immunity is specific to Lori and Chad's case. More wine. Oh, another Lori. This is a good question. What are the benefits of a speedy trial? Just to get it over with quick? I don't understand why you wouldn't want to take the time to get your ducks in a row. That's a really good point. But you have to weigh that against the fact that while the trial is pending, the prosecution is continuing to investigate the case. So they could turn up new evidence. They could turn up new sources. All of that could develop as a result of the delay. So the DNA is actually a pretty good example. If this case had gone to trial at the time that Lori was supposed to have her first speedy trial, all of that stuff that has been developed since, none of that would have come in. So DNA, consumptive DNA, new DNA being turned up on the duct tape, any of those things wouldn't have come in because they wouldn't have been developed. So it's kind of a balancing act. You have to weigh whether pressing on for a speedy trial benefits you because then the state doesn't have time to keep investigating, or whether waiving your speedy trial and delaying gives your attorneys more time to turn up exculpatory and mitigating information. I think it's different in every case, but in general, I will say that delay works on behalf of the defense, and there's a reason for that. Memories fade, witnesses disappear, people die. All of those things happen that make it more difficult to prosecute a case. So the general thought is that delay works towards the defense. But There are many defendants that say, no, I want my speedy trial. I want to hit the ground running. I do not want to give the prosecution any more time to investigate the case. I don't want to give the prosecution any more leeway in how they're managing, prosecuting, investigating the case. So, balancing. Question. Hi, Tara. Why aren't the prosecutors concerned about the timing on Lori's trial? Why didn't they push to get the trial started within the speedy trial deadline? I think they are concerned. I don't think that they have probably pressed the issue as much as I might if I were a prosecutor. I don't think that they have been as adamant with the court as maybe they should have been, but they have raised at every hearing that has to do with scheduling that Lori has not waived her right to a speedy trial, and that they are prepared to try the case within the speedy trial requirements. So I mean, I don't know that there's a lot more they could do. It really is up to the judge to determine whether or not when a trial will start, and whether or not to go beyond the speedy trial limits. Tickle Pink. Don't you think everyone contacting the judge will just make him mad? You know, I don't know. This is something Larry and Kay have asked for, and I am going to honor their request and tell the people who follow me that that's what Larry and Kay would like people to do. It's completely up to you whether or not you want to write a letter to the judge, drop him a postcard, whatever, and whether or not you think it's going to be helpful. I don't know. We know that Judge Boyce isn't necessarily the kind who changes his mind if new information is developed. I don't think there's any new information. He realizes that citizens of Fremont County have a right to know what their government is doing and have a right to sit in trial and make sure that their government officials are doing their jobs. He knows that the family are all going to be coming from Fremont County, as is he. He understands the level of hardship that might put on people, because all the witnesses and all of many of the victims and defendants' families are all from Eastern Idaho. So, you know, I honestly don't know. I definitely encouraged all of the family members to contact Judge Boyce and to let him know the hardship they felt it was going to be for them. But I can't say. I don't know what's in Judge Boyce's head. I had been concerned from the beginning that I felt like inundating the court with letters might not be the most effective way to handle it. But I think there is a 40% chance at this point that he will allow in live streaming for the trial. And I think that has much more to do with his thoughts about the victims and their families and his thoughts about the citizens of Fremont County than it does with anybody else involved in the case or any other average citizen. So, Jessica, howdy. If Lori is found guilty, does she still go to Arizona? Absolutely. Those charges are still pending. She will go to Arizona. She will be arraigned on those charges, and she will face those charges and either plead them out or be tried. And then the states, if she's tried and convicted in Arizona, the states will have to determine the order in which her sentences will be served. Hi, Bo Peep. Thanks for joining us. Um, this is an interesting question. There was some indication when Kara Kernodle, Xana's mother, was interviewed by Ashley Banfield, that Kara had given her attorney, Ann Taylor, power of attorney. Power of attorney can mean a lot of things. Powers of attorney are kind of fluid things. You can give a person a power of attorney that gives that person the unlimited right to do all of your business forever. You can also give someone a power of attorney for a limited time or a limited reason. So, not knowing what the contents of this alleged power of attorney are, what I heard was that it was a power of attorney to help her get into a residential treatment program. I don't know what that entailed. If you go down to the DMV and you want to give somebody else the authority to go down and register your car for you, you give them a power of attorney. It's for that discrete, limited purpose. It's limited in scope and it's limited in time. It expires. So it'll say, for the next 30 days, my wife can go down to the DMV and register my car, or my dad or my neighbor can go and do that. And by operation of law, it expires on its face. If you don't register the car in 30 days, it expires. So there's no way to know the contents of that power of attorney. Now, I know that most people who think about powers of attorney think about them in terms of that sort of blanket power of attorney you might give a spouse, or your parent might give you if they're becoming unable to manage their own business. And those things are much, much broader than other powers of attorney. So they're not all created equal. Unless we really know the contents of this power of attorney, it's hard to say whether that could create a conflict of interest. I would say at this point, because conflicts, and I don't want to go too far over, but I'm going to go a little. Because the definition of a conflict is that a lawyer has two clients that are adverse to one another. Okay, that's the definition of a conflict. So first of all, you have to look at whether or not you have two clients adverse to one another. For example, in the Vallow-Daybell case, everybody kept saying Mark Means had a conflict because he stood up in court and told the judge, I represent both of them. I represent Chad and Lori both. And he stood up in court and said that. And at one point, before Chad was arrested and charged, he was advising Chad of what to do. There were already search warrants being served. There was already other things going on that Chad needed advice about, and he was giving Chad advice. So technically, he was the lawyer for both Lori and Chad. Because Lori and Chad clearly are a heartbeat away from being adverse to one another, that was a clear-cut conflict. The fact that this lawyer represented Kara Kernodle at a time when neither one of them could have known that she was going to be appointed to represent Brian Kohberger, and that Kara Kernodle's daughter was his victim, that's not a conflict, because Kara and Brian Kohberger are not adverse to one another in a legal sense. Now, I understand that this feels wrong. And I've been the first one to stand up and say, listen, I understand it feels creepy. I understand it feels wrong. I understand it feels a little incestuous. I get it. But when I'm asked, is this a legal conflict? My understanding of the rules of professional responsibility and all the years of having to do ethics education, my understanding is this is not a legal lawyer conflict of interest. That Ann Taylor does not have a conflict of interest between Kara Kernodle and Brian Koberger. So now, as I said before, conflicts can arise. If somehow this conspiracy theory about how they're all involved with drug trade is real, then it's possible that conflict could arise. And at that point, at the time the conflict arises, Taylor would need to withdraw and have other counsel appointed. I do want to point out that for the state, this is purely a financial consideration. Now, legal ethics are not do not take a backseat to finances, but the decision to appoint Ann Taylor, unless she has a clear-cut, true conflict, are purely financial. Because every other lawyer who they would have to bring, who they could appoint to this case, mind you, there are 29 people on the Capitol roster in the entire state of Idaho. Only 13 of them are qualified to be lead counsel in a capital case. Ann Taylor is the only one in her judicial district. So what that means is we know that at least 2 of them are out of the running because they're already representing Lori Vallow, and they're not going to take another capital case. So now we have 11 people in the state of Idaho who could be appointed to represent Brian Koberger. Only one of them lives in the district. Everybody else will have to come in from out of district. That costs more money. That costs travel time. That costs hotels and per diem. And it just can double or triple the cost of having that lawyer represent that client. So given the choice of having somebody in the district or somebody out of district, the state is going to want somebody in district, as long as they can ethically represent the client. So for the state, it's purely a financial decision. Gritty Gret. How do attorneys handle antagonistic clients in a joint trial? With a stick. Sometimes they want to, trust me. I've been in those cases where you're like, if I have to take a stick to my client. I will say that most clients who are in trial, it's often, even for clients who have been in the system before, it's often their first experience being in a trial. And it's scary. And it's bewildering because there's so many things going on that they don't know and understand. And the attorney's trying to whisper and explain while they're in the middle. I mean, it's very overwhelming. And that can come out a couple of different ways. It can come out as really antagonistic, or it can come out as, deer in the headlights. So I think that if the lawyer can identify the source of this distress and help their client kind of ratchet it down, that helps. But remember, there are often times that these 2 co-defendants hate each other, and they're blaming each other, and they're trying to get the best of one another. And I think it takes a couple of fairly experienced, skilled lawyers to be able to sort of sit in between them, separate them, and say, you're not doing your case any good. Because again, clients are sitting there thinking, I don't I mean, you sit down with your client and say, see those people over there? You don't want to piss them off. You don't want to make those jurors mad. You don't want to make those jurors think that you're a jerk. You want those jurors to think you're an okay guy or woman, and you're going to want these people to think, it's kind of likable. It's kind of an okay guy. I mean, it's kind of okay. You don't want them to see you as this, particularly if the case has to do with any kind of violence. You don't want the jury to see you as this angry, nasty, antagonistic kind of a person, because that's just gonna fill in the blanks for them. You want your behavior to be to cause the jury to say, wow, that doesn't sound like the guy I see sitting there. The things I'm hearing don't sound like this guy who's sitting here. And I think having that conversation with your clients and explaining that to them and trying your best to explain what's going to happen are the best way to keep clients under control. My darling daughter is just as in chat, and her comment was, laugh at LOL, just read her book on divorce to figure out how to deal with antagonistic clients. Thank you, KJ. We've gone about a half an hour over now, so I think this will be our last question. If you have other questions, which we have not caught in chat because it's been bumping along pretty quickly, please put them in the show notes, because tomorrow morning I'll get up and have coffee and I'll read your comments and I answer questions in the comments. So please do that. I'm going to add the address where you can send letters to Judge Boyce in the show notes, and I will let that be what it will be, because I'm honoring the request for Larry and Kay. And once again, thank you for all your generous donations. We've been trying to add your names to the ticker at the bottom. If we didn't catch you, we'll catch you next week. And please subscribe. Please hit the like button. We have 446 people watching, so please get out there and hit the like button. Like I said, makes a big difference with true crime, because we walk a little bit of a fine line, and we definitely need YouTube to know that you enjoy our content. So could you stick Tara's question back up so that I don't miss it? Thanks. When the joint cases are tried, what is the process? Do the attorneys take turns arguing? Do they handle one case and then the other? No, they take turns. So John Pryor will do opening statement. Jim Archibald will do opening statement. Prosecution will do opening, well, reverse. Prosecution goes first. Defense, prosecution gets a little bit of a rebuttal, and then they go forward. Prosecution calls their witnesses, then Jim Archibald will call his witnesses, and then Pryor, or vice versa. It depends on however the court arranges it. But each defense attorney will be able to call witnesses. Now, typically they'll talk about, we're all going to be asking questions of the same witness. I'll do, let's say it's Melanie Gibb. So John Pryor will ask questions on direct of Melanie Gibb, and then Jim Archibald, who has also called her as a witness, can ask his questions on direct. The prosecution will have the opportunity to cross-examine, and that's the way it'll go. They'll take turns, and then at the end they'll each do closing statements, and where you would usually have one closing statement, you'll have one from each attorney. So, and the same jury will be deciding both the charges for both defendants. We've heard no indication they're thinking about two juries. And I think that would be extremely difficult to manage. I think it would be very, very difficult for any judge to manage. And I worry about Judge Boyce just because he hasn't been trying jury cases for 20 years. So, Thank you so much, everybody. Thanks for your great questions. Thanks for thank you for, Larry and Kay gave me a slightly different address than the one you just put up, Michelle. So maybe we'll put them both in the show notes. Once again, thank you so much for joining us. Thanks for spending your Friday with us. We know that you could be other places. So thanks for being here with us. I want to thank my moderators, Michelle and Brenda. They do amazing work. Thanks again for all of your super chats for them because it makes a difference for them. Have a great weekend. I'm going to be quilting. For those of you who are interested in joining the True Crime Quilt Guild, that's in our show notes. I will be putting out the next 2 videos on the next 2 squares. My daughter's beautiful quilt, I always get this backwards. My daughter's beautiful quilt is right here waiting for backing and to be quilted. Our first square over here for our True Crime Quilt Guild quilt, that's our center block, is right here. And we're going to have much more to show and tell in the next weeks coming up. So if you're interested, check out our show notes and quilt along with us. Have a great weekend, and we'll see you all on Wednesday. Good night.